grievance process, Mr. Woods. And company. Oh my goodness, oh, I'm so sorry, Dr. Veloz-Powell.
Dr. Powell's going to give the presentation with just an brief overview of what's statutorily required and not delve into all other facets of Chapter 21, but this particular piece for the particularly for those of us that haven't had the experience with it.
Good evening, Board of Trustees, Mr. Chambers. Tonight I am going to go through the process, the grievance process, so that the board will have a better understanding of how the process works, the timelines, and then for future reference that you'll have this information. All right, some of the things that we will be talking about are the notifications of the grievance, how we're required to notify regarding the grievance procedures, the guiding principles, the process, and then each of the different types of levels, the informal, level 1, 2, 3, and then giving you some case reviews. So in regards to notification, the law does require us to make it public to the employees, to the parents, and to the community about our grievance process. So we do have 3 different types of grievances. We have what we call the employee grievance, which is policy DGBA, and we post it on our website through the policy manual. We have it in our employee handbook, and also we provide that information in our human resource department. We have a parent grievance format. The parent grievance is policy FNG, very similar to DGBA, but it's designed for the parents to be able to respond to file a grievance. So that is provided in the student handbook, provided in the curriculum instruction department. They guide them if they have issues. They guide them to where to go locate those forms. And of course, also on the webpage in the policy manual. And then the last type is for the public, which is policy GF. Again, same place, webpage or in the policy manual. You can also find that through the superintendent office. They can guide them where to locate it, or public relations department, or even human resource department. And then finally on the webpage. So when we're talking about a grievance can be filed for any reason that somebody feels that they have not been treated fairly or that they have an issue that they would like to get resolved. Of course, our #1 goal is to resolve the issues in a very informal format. We hope that we can do it informally, so that way that there's trust between the employee or the teacher or whomever's making the grievance complaint. So we try to do it at the informal level with the person that they're grieving. So for example, if it's at a campus, it would be the teacher and the principal. So we try to do that informally. If that does not work and that doesn't get resolved that way, the employee or the person making the grievance has 15 days of the first piece of knowledge. When they become aware of a decision that they disagree with, 15 days after that they can file a grievance, a formal grievance. And again, that's filed with the lowest level administrator, or the person that can remedy the situation. There may be some cases where it may not be the campus principal, it may be a policy issue that may have to come to central office, and we'll start at a higher level. But anything that can be solved on the campus level will start usually with the principal or with a supervisor in a department. There's some definitions that you should be aware of, just how things work. The response is considered a written communication. So anytime you give a response, it has to be in writing. The delivery can be delivered in multiple methods. One, it can be hand delivered. It can be electronically delivered through email, faxed, or U.S. mail. However, whenever any of these methods are used, it has to be received by the department within the 10 days. So it needs to fall within the timelines, regardless whether it was mailed to them or they're emailed. A representative, usually a representative is considered, an attorney may be a representative for an employee or for a parent, or even a teacher organization representative. So there are different types of representatives, but employees or people filing grievances are allowed to have a representative available to them. Consolidating complaints, many times complaints that are arising from one event or a series of events can be combined into one grievance. That way it can be handled at one time. Timeliness and untimely, many times we encourage our employees to make sure to follow the timelines because they have to adhere to the timelines for the grievance to continue in the process. And the last piece is the form. We would ask that whoever is filing the grievance fills out the form, because there's specific parts that they have to ask, like remedy, what is your remedy? So there's parts of the form that we need filled out. Again, the informal, we encourage all of our employees or people that are making complaints to resolve it at the lowest level. Who is in that informal? It's usually the grievance. Sometimes the grievance representative may come along, but many times it's just the grievant and the administrator. And if there is a representative, many times the administrator may call a director or somebody that can help guide them through that process. Why do we have this? One, it allows for a more informal decision. It's not usually tape recorded, it's less formal. It's resolved, the resolution is confirmed, and we do put it in writing so the employee does know what the resolution is. And if it's not resolved, there's always an opportunity to file a level 1 grievance. So at the level 1, when it does get to the level 1, who's involved is the grievant and the grievance representative, the administrator and the administrator's representative. The goal at this level is for the person that's hearing the grievance is to stop, look, and listen to the person's complaint. Many times people just don't feel heard, so this is an opportunity that the person making the complaint is fully heard, so it's to stop, look, and listen. The role of the administrator is representative to the grievant, so the person that's coming along with the grievant should be there to listen, to provide guidance, and maybe provide some options for the employee and explain the grievance process. The role of the administrator's representative is to ask questions, probing questions, to find out more about information that they may not have or may have not provided, to provide technical assistance and guidance about policies and laws, and then to make sure we're tracking the timelines appropriately so that we're staying within the timelines. At the level 1, the grievant must file it within 10 days of the issue. Complaint is filed with the superintendent's level 1 designee. Usually it's the supervisor, either in a department or the principal. Administrator must review all the information in the level 1 record. Sometimes a person will submit at the level 1 additional documentation. The original complaint must be completed on a form. If it's not, we guide them on that form so that we can get the remedies listed on there and we have all the information we need. And then all documents need to stay together in that packet. And the administrator, once they receive it, has 10 days to file to schedule a hearing. And then the conference is held, and then the administrator has 10 days to respond. If the grievant is not satisfied with the level 1, they may submit it to the level 2. The level 2 is usually an administrator from the central office. For human resources, I'm the level 2 hearing officer. For academics, it's usually either an area superintendent or Jackie Armwood with student services. That's the level 2. And so that the purpose of the level 2 is, again, to hear it from another person, to hear it at a different level, to stop, look, and listen. To establish some administrative procedural guidelines, the hearing officer guides them in the questioning and makes sure that they get all the information. Present any information at this time, if there's exhibits, to make sure that we provide that at that time, and then the timelines need to be followed again. If again, at the level 2, that the employee is not satisfied or the grievant is not satisfied with the remedy, the grievant must file within 10 days. The complaint is filed at the superintendent's office at the level 3. Whoops, that's the same one. Sorry. Oh, okay. So at the level 3, it's basically the same thing. They must file the complaint. They get 10 days to file the complaint and to, here we go. And to hear it, so it's the same procedures as it was in level 2. So when it gets to a level 3, this is where it's a little bit unique and different, and I'm going to explain this process to you in case you have any questions. So at the level 3, it's to be considered by the board. That's when the board gets to make a decision about it. The grievance documents are submitted to the board ahead of time, usually on the Friday prior to the next board meeting. You get a notebook with all the documents from both the grievant and the administrator in a binder explaining the whole grievance. You review it. And then what you have the option to do is you can uphold at the board meeting, on the next Tuesday's board meeting, you can uphold the level 2. You can come before and uphold what the level 2 says, and you notify the grievant in 7 days. You can vote to take no action at all. You can come back after reviewing the information and you can take no action at all. When you take no action, what happens is a level 2 is the one that becomes the last level heard. So that's the level that takes precedence, is the level 2 hearing officers upheld. And also you notify in 7 days. And then the third option you have is to have a formal hearing. And during the formal hearing, you can decide to do it two ways. Either the board members can hear it, or we can have an officer. You can choose somebody to hear it. You usually get a representative, an attorney outside of the board to be the hearing officer. And at that time, you hear the formal complaint. It's audio taped. It's kind of like a court reporting. And then we have a court reporter. We have both the attorney and the grievant and their representative present, and the board hears it. And then at the end of that hearing, the decision is made by the board, and that has to be put in writing by the board. I'm going to have Eric share some examples of different types of when those things are solved at different levels and answer any questions that we may have.
Thank you. Good evening, everyone. So I think it's important to kind of just talk from a concept as far as grievances. Those of you who have been on the board a long time understand that the process is something that you don't see until the very end. You don't see until it's a level 3, and sometimes there's questions about that, and sometimes those are addressed in that way, but sometimes you don't really know what happened at the lower level. If you look at statewide, and most of your policies you know are TASB promulgated policies. Those policies are ones that TASB has given you, y'all have adopted as far as for your local policy, and that's your grievance policy to set. It's then disseminated through your handbook, and it's actually passed out to the employees so they know what's going on. The vast majority of grievances in all districts, including Alief, are actually handled either informally or at the level 1. That's how we actually want it to be done, because that's what actually promulgates good things for the employees as well as good things for the district. And some of these things that we've talked about in concept before, such things as if you don't have a grievance aired, you may not actually know as far as the supervisor that there's an issue. You may not know as far as the first level, the employee may not have an opportunity to actually voice their concerns. We want that as far as an employer to make sure that we have stopped and looked and listened to those things. The other thing that's important for the employer, though, is from a risk management standpoint, you may not know about something happening on a campus or in a particular area or whatever it may be unless those things are brought forward. So that's something that actually helps not only the employee but the employer as well. And lastly, it's important from the standpoint of the process itself works in order to move that grievance, move those issues, move those through the process in order to make sure that the employee feels that they're heard, and to make sure that if we can remedy it before positions get hardened. By the time it gets to you guys, unfortunately, a lot of the time, the positions are fairly hardened from the standpoint of who wants what. There may be attorneys involved, there may be other folks involved, and unfortunately, a lot of times the original grievance was not actually something that actually has gotten to you in the point to where you can resolve it. We don't want that to necessarily be the case. So when you look at the different grievances and you look at the resolved at informal and resolved at level 1, the vast majority happen. Level 2, you have a much more extensive record that's involved. And when I talk about the record, and I know that I've had this conversation with some of you over the years, the record is everything that was presented in the grievance and or response to the grievance during the time period it came through the different levels. And I use the term levels only from the standpoint of that's how it's outlined in your policy. So the informal really doesn't have a lot of submission, but the informal must have a decision made so it can progress either to be resolved or progress to level 1. Then the information, the vast majority of the information is actually presented at the level 1 hearing. The level 1 hearing sets the majority of those issues into place. Once those issues are in place, they don't really get modified as it goes up. You have a very limited amount of ability to present additional evidence or additional issues after that level 1 is presented. So by the time it gets to a level 2, the issues are already locked in. Alief, along with a few other districts in the state, actually several other districts in the state, have what's called a bifurcated level 2. And I think Dr. Veloz-Powell did a great job of actually explaining that, but I think it's important to understand how that really works in a lot of ways. Alief has the position, a lot of colleges, a lot of junior colleges also utilize a similar policy to where they have the information presented to the board, what we would call almost an on camera, like in court. to where you get all the information in a written format, written arguments from the administration, written arguments from either the grievant or their attorney, and then you have an opportunity to consider that. That allows for a much more efficient process for y'all than some districts that don't see the actual grievance materials until maybe the Friday before their Monday or Tuesday board meeting. They don't have much time to actually look at it. You, luckily, have much longer to do that. It allows you to consider the information, and then you can make a determination as far as to what you want to do. Whether that may be granting an oral hearing, or may that be affirming the level 2 decision, or not doing anything, which also affirms the level 2 decision. All these are issues. If you do actually have the hearing, then you obviously have the same ability to affirm, deny, or allow it to go forward. I think it's important also to note that, you know, as I indicated, the vast majority of those things are complete early on. But also, the grievance process itself is an appropriate process. It's something that's actually outlined in the government code. It's outlined in the education code. It's something that not only helps the employees, but it helps the employers. And y'all been doing a very efficient job.
Any questions or?
Hi, I have a question. Okay, so I heard the word like remedy. So do you have options to check for the remedy, or do you have to know what a remedy is? Because I'm thinking about it from a parent's perspective, right? I have no idea what that word means.
Okay, so for remedy, somebody, what is it that you want, what's the outcome? And many times they write in, I want to have my reprimand removed. I want my child to get to retest, or those are the remedies, what you want from this decision.
And what are you asking for?
Okay, so is that what it says like on the form?
It just says remedy, and then they write the sentence, the grievant writes what it is they want.
So if I don't know what a remedy is.
So many times they can get someone to assist them, and if they are not sure how to do that, like they may come to my office and I'll say, what is it that you want? And I'll help write that remedy for them.
Gotcha.
And I remember on at least in the instruction department, and I don't know if that form has changed since I left, it actually says, what do you want to happen as a result of whatever happened.
What is the remedy you're asking for? What is the
What would
remedy
you
you're
like
asking
to
for?
see happen?
Okay. So that'd be the first thing. And the second thing is, so let's say that it comes before us, right, as a board. Is there some documentation that's like data quantified? So like we know that we've heard 50 grievances out of 5,000 that have been done at level 1. Do we get any of that kind of information where we know like how many of these we deal with on a regular basis?
No, not normally, because so many of them are handled at the very informal, and we don't necessarily track those on the informal, so no, we don't normally share that. I do have data of how many we do at the level 1 and level 2.
Okay, so I guess like, so if I'm an employee, I heard a lot about that, so the process is the same for a parent, right? Just that the form is different, it's the same?
Yeah, the form is very similar in all 3 cases.
Gotcha. So let's say that I want to grieve 20 things. Do I need to do 20 different grievance forms?
As you remember where we say you can combine them, if they're very similar from the same situation, we can combine it in one grievance.
Yeah, if they arise from the same or similar situation, then they should be contained in one grievance. It shouldn't be what we call serial grievances, where a family thinks, or an employee thinks, or a community member thinks that they have to file 20 different grievances to address one thing that all flowed from the same action. So the idea of that, and it's contained in your policy as well, but if for some chance you were having an administrator that received 20 grievances about the same thing, the typical procedure I would imagine from what I've seen with y'all and other districts is you would contact that person and say, we're going to consolidate these 20 into one because these things are all arising from the same issue.
So then they throw them all out at the same time.
I wanted to ask a question because I do know that it exists. I know my policy exists. Where is the form located for parents to?
It's on policy handbook, but many times parents will come in and we'll guide them with that. So in public relations, they can guide them, superintendent's office, or we can guide them as well.
The reason why I asked that question because I also remember some time ago, vendor had a complaint. And it was kind of difficult to guide them to a specific form because, you know, by policy, they have the right to grieve as well. So, you know, so on occasion, I think Mr. Wilson and I had a conversation about 2 years ago about that. On occasion, when the individual presents a letter, it is informal. if they are presenting a letter of a formal complaint and it's stated that way, and as well providing a remedy, do we accept that, or do we demand that it's transferred to a form?
We accept it and we invite them in and we ask questions that may not be in their complaint that is on the form.
All right. When vendors come in for complaints like that, who do they normally go through? It's not HRD, does it go through your office?
Usually procurement.
Procurement.
Sometimes it starts with me in the office, so we can answer the question immediately there, but if it's a specific issue, then they usually look at Adam's name or someone that's on the contact.
In all three, the closest to the problem who can solve it is the best. That way,
Yeah, because typically we do, we look at grievances and we always think about employee grievances, but, you know, it's good to know as well that, you know, the community has the right to come and grieve as well. I mean, they don't have to have it documented or.
Well, the government code is real clear, it explains that your community has the right to address, your constituency has the right to address their elected officials. I mean, that's pretty much ubiquitous through all types of government, but y'all have it very clearly outlined in your GO policy. Some things, as y'all know, don't necessarily fall into one of the defined grievance categories, and if you look especially in the FNG, the parent one, it'll have a list of other things that the grievance may be redirected into, depending on what the nature of it is. But when it comes to the DGBA kind of employee, almost everything is a work condition of some kind. It may not be remediable, but it may be grievable.
I just have two quick comments, and I know just from experience and have gone through, I don't know, several, but a few of the grievances is as an elected official, it's very difficult. Just speaking of the board members, is that you'll get approached at the gas station, at the convenience store, at HEB or whatever, talking about something they want to present, and then give you a whole earful of everything that's happening. It's almost a practice that I'm doing. It's like, well, if I think it's going to go to a grievance 3, you need to go through the channels, also the right channels, go through that, because if I know too much more about the case before it's all really happening, then I really have the obligation or the duty to recuse myself. So I'm actually hurting that individual's case. So I'm like, okay, you know, I'll hear it when it comes to a level 3, if it comes to that point, and then I can make that decision. But if you give me all the details and you're talking to me throughout the whole process, then, you know, I have to really recuse myself. Is that correct? To be fair, so I can really hurt the case. So as a board member, that's just my own suggestion or recommendation. And then even third and the final, we've had a thing where maybe the documentation wasn't, you know, I know when we get our final book and we go through this and we read through it and we go through all the details of it, and we're like, man, and our emotions in there, because as parents and community members and in our own field, we get emotions like, oh, they're doing this or they're doing that, and we start adding to it the book ourselves and our thoughts. That's not good. We have to base our decision on that book and that book only. We can't read into it, we can't add things to it and say, oh, what about this? Can we get that evaluation, or can we get that letter, or can we get that? If it's not in that packet, we can't base off of that. And so, you know, whereas to the teachers and the staff and the union, I mean, really get the documentation together so that we can make a really decision, an informed decision, and have all the data in front of us. Is that, you feel the same way, Ms.?
I agree to the extent that I tell anyone, I mean, with the experience of being on the board, and as Ms. Moreno say, the emotions that you have, I mean, you have to make an informed decision, but your emotions doesn't go away. Mm-hmm. So, I mean, as a result of that, I do tell people, and this is not for A-League, this is anywhere, I mean, I'm in the field of education now, and I say, if you have a complaint or concern that could potentially turn into a grievance, you better write your heart out at the very beginning, because there's no way that you can go back and add the extras inside of that document. So, and I do say that because after being a board member, you have all of these, you know, what if thoughts, but you always have to go back to, this is a snapshot in time, and this is all you're looking at is that snapshot in time. You know, and to making that decision, I agree with you, Mr. Moreno. I'm agreeing with you quite a bit tonight. I don't know what's wrong. It must be the coffee.
It's gonna be weird.
And we do, obviously, what we mentioned at the beginning, we always try to do it informally. In fact, like today, I heard somebody, we encourage, let's do this informally, and if it doesn't, then you go to level 1. So we always encourage people to do it informally so that there can be conversations back and forth and that it's resolved in a very easy fashion.
Well, one of the things Ms. Butler brought up that I had not thought about before, I mean, and I've heard the statement that, and I know for a fact that we have decreased these quite a bit, but it would be kind of it would be kind of beneficial to understand that, you know, yes, there were some level 1s, but they were taken care of. Because obviously, if they were not taken care of at the level 1, they would proceed to the next level. So it'd be kind of, you know, without disclosing names and situations
Sure,
and things
I
like that.
can provide you with that data,
Yeah.
because we track those to keep on the timeline.
Right. It'd be helpful to know that, hey, you could have had X amount before you, but this is what happened, you know, instead. Do you have questions?
I do. I'm new at this, so I just have these questions. So if an employee is being maybe recommended for termination, that has to go to the board. Okay, so how far in advance are they notified?
Remember, we talked about the 45 days in advance that we have to
That's what I
notify.
was
So
saying.
at that point, that's when they would recommend, like they would normally grieve the recommendation of being terminated, or they may wait till they see if they get terminated and wait till the actual termination, and they grieve at that point. So anytime an employee feels wronged, they can grieve.
Okay, so that is why I asked that question, because I was trying to figure out, because I know that we're looking at changing that policy from 45 days to 10 days. So I'm wondering, right?
Well, through the board policy committee, y'all are reviewing that to
We're-
determine what kinds of changes to make. That's correct.
Right, so my question there is, if they choose to grieve, do they have enough time in there to do all of this?
So they would grieve the termination after they've actually been terminated. So that would give them time. And if the grievance goes in the favor of the employee, then it's overturned and they get right back. So yes, they do have time to do that.
Okay. Okay, and if there's ever, go ahead.
No, I wanted to make sure that it's really two separate actions. And so and I have this question come up a lot in spring from different districts. So the proposal for non-renewal or the proposal for termination or proposal for suspension without pay is a different element, and it's a board vote. So you actually start the action. Now, the employee may have been informed beforehand that they're going to be proposed for non-renewal or termination or whatever it may be. And actually, y'all have required that the HR department make sure that they do that before that happens. But they have a different action to appeal the proposal of non-renewal or proposal to terminate. The grievance is really separate than that. So the unusual thing about it is when you have somebody that's actually grieving the action that the board took, but it may actually be in the hands of an independent hearing officer, or it may have actually already concluded. So there really are two separate paths, and they're not always together. A lot of times if they're represented by counsel, they'll forego the grievance process because they're actually contesting it through the appeal of the actual proposed action that the board took.
Because there's a complete appeal process for termination that's separate from the grievance. But many times people turn in a grievance form for their principals even recommending it. So they can start it earlier, but if it goes through the termination, there's a different process for that.
Are they ever, so are they given the option, if it's something that's going to maybe give them a sanction on their certificate?
Are they given an option
No.
for?
Oh, I was gonna say it's a situation where there might be a sanction on their certificate, or it might go on their file, whatever. Is there an option for them to resign as in lieu?
Yes, however, I am always required to report it and to TEA, so SBEC will receive that notification because we're required by law to do so. There's some things that are required for those type of things. So regardless, that we do, and we let SBEC do their investigation.
Okay.
But yes, they are still allowed to resign in lieu of termination, but that sanction is with TEA. They determine that, not us.
Okay, so do you give them the option, or they say, oh, I don't want to be terminated, can I resign? Or do you say, or is it TEA says you have to give them this option?
We do both. Sometimes they ask to resign, and we also offer them the resignation because it's timely, it's less costly. We still have the same ramifications. They still get sanctioned. They still, the things for us, we still require them to do, so it doesn't change that. Does that make sense?
And again, you may be talking about two separate paths again, Ms. Rose. So if it's like a performance issue or something to where they just want to exit, as far as that, they can have a resignation and they can exit on that, and that's not necessarily a report to aspect.
Right.
But there are certain offenses, as you probably remember and aware, that regardless of whether they resign in lieu of termination or resign pending termination, that Dr. Veloz-Powell would still have to report anyway.
Right.
So unfortunately, they have to be notified of it under Chapter 21, but they wouldn't necessarily have the option about whether or not they have to report that, because they would have to do it either way. The
Right.
timing may be different depending on what it is, but they would still have to report it.
Got it. Yeah, now that I understand. I'm just asking all these questions because I know that there's the other piece that I have to, the committee has to review. So I'm asking all these questions now.
I want to go back to as well what you were saying, Mr. Nichols. These are two different things. We want to make sure that the conversation still leads more towards the grievance conversation versus termination, because that process goes a little deeper, right, into deeper. And we can have another board workshop concerning that as well, but just looking at the grievance process and walking through that is what we're going to stay with. I didn't mean to say that you're off track. Just wanted to kind of reiterate what Mr. Nichols, I heard him say that twice, that is true. You know, we tend to, when we look at it from that point of view of employees, we tend to kind of lump it all together, just as Mr. Moreno was saying about, you know, we do have emotions, we're human. So when we look at it, we're looking for different things, but the purpose of this discussion is to understand the process, because we, as committees, have been talking about process. We want to be more process-driven so that we know that we are fair and equitable in what it is that we're doing. So in talking about this process, you know, no one should be in the dark when these things come before us. And even so, we have a guide to go back, the roadmap, so to speak, to go back and to look into. Was there anything one other thing, Dr. Powell, it would be interesting to know as well how many grievances that we've had. You've been here, what, 3 years now? In the last 3 to 5 years that required a hearing officer versus, you know, because I think Ms. Moreno, you and I don't know if Dr. Charles has seen any of those, but we know in the past what it looked like. And I do recall that we did have at least one done. So it'd be good to know how many have had that versus, and the representation. I think we've only had one that I can remember that did a self-representation, and even the board was like shaking their heads saying,
All right, we'll get that data for you. Provide that to you.
okay. So that would be helpful, that kind of data input. Would that be okay with you guys, to information to see?
And one final thing for all the board is, I know years ago, a few years ago, we had some questions regarding the packet that was provided to us, and before Dr. Brown was here, that it was, you know, like, was that the complete packet? Was that everything? And with Dr. She submits a letter on the top of it saying, this is all information. I'm confirming that everything I'm giving to you is everything that's in the packet.
Correct.
So everything is on there.
It's on there.
So just let us know. So that's okay.
If there's nothing else, thank you so very much for this report. We look forward to hearing from you more in the future. Okay. So the next item on the agenda